If parties to a written contract intend for the contract to recite their entire agreement, the parole evidence rule prohibits any evidence about a contract's terms beyond the writing itself. After a man tried to return jewelry to its seller, the court penned a gem of an opinion about parole evidence in George v. Davoli. Joseph Davoli owned Triple J Turquoise Jewelry. John George bought jewelry from Davoli for $500. At the time of the purchase, Davoli and George signed a memorandum of sale which stated the purchase price and included a provision for the return. Under this memo, if George decided the jewelry wasn't acceptable, he could return it, and Davoli would provide a refund of $440. The memo didn't address the time frame for returns. On Wednesday of the following week, George wanted to return the jewelry, but Davoli refused. George sued Davoli for breach of contract. At trial, the memo was admitted into evidence. George's attorney called one witness, Davoli. On cross-examination, Davoli testified that George and Davoli also made an oral agreement that George needed to make any returns no later than the Monday evening following the sale. According to Davoli, because George tried to make the return on Wednesday, it was too late. There wasn't any evidence refuting Davoli's testimony about the oral agreement. So, admitting the testimony into evidence would have been fatal to George's breach of contract claim. Because the memo was a writing about the sale, the judge needed to decide whether that writing meant Davoli's testimony about the oral agreement wasn't admissible.